And our main speaker will be Rick Unklesbay, and he graciously allowed Laura to say a few words first. And I want to introduce Laura. Without further ado, Laura Conover.
Yes, thank you, Rod, and thank you, Rick. Very gracious. My name is Laura Conover, and I am running for Pima County Attorney. These ballots will actually get to you in July, so this is a sprint, and it's very nice to be here with you, and I'll just take a couple minutes. I am a lifetime Tucsonan, and this issue was a passion for my mother, and she knew even at an early age, that I wanted to go to law school. So the very first time I set foot at the U of A Law School was really as probably a 12-year-old, 14-year-old maybe, and Rick Unklesbay and Andy Silverman had a debate at the law school about capital punishment. And my mother wanted to just start teaching me about the issue and teaching me about the law, and it began as early as that. And so yes, by the late 90s, in high school and then in college, this became my issue, and I assure you, as you all know, in Arizona, it was very hard to be so vehemently and passionately anti-death penalty in Arizona at that time. And I am so proud of you and your work that as a candidate now, I am being quizzed harshly to make sure I am anti-death penalty before any, yes, indeed, it's true. It's true, before people will sign my petitions, before people will sign up to volunteer for me, it has to be clear, and really, it's a relief that it's on record from the 90s because of the coalition of Arizonans against the death penalty that was my very first activism and my very first passion. I have a criminal justice reform platform. I truly believe that reform is responsible to the taxpayer, and then also must be done in a humane way. And it's something we can all get behind universally. In my federal court experience, I have now built up quite a bit of administrative and management experience. And so I feel uniquely qualified and ready to be the administrator of Southern Arizona's largest law firm. I'm gonna pass around a petition if you'd like to sign it, but what I also wanna do is a piece of paper if you wanna give me contact info so we can continue this conversation forward. But I want to thank Rod again for his kind words, and I want to thank Rick for being so gracious. Here he is.
Sorry, I've done a bit of research on Rick, so we've never met before. I think one of the themes of my opening introduction here, which I swear I will keep short, is that what a small town Tucson is, and how, we're so interconnected here, and no matter what side we're on, it seems like we do patch it up sometimes after bitter elections at times and things that happen. There was never any bitterness when Claudia ran against Barbara Lawal that I was aware of, and when she got the Green Party on the ballot. I'm a hardcore Democrat now, but I started out with the Green Party, so we evolved. I just want to say one little thing about how I got started, which you're not here to hear about, but I just went out to Florence. It just felt, I had two young sons, and neither one, they were not old enough to get in trouble yet, so I didn't have that much experience with the criminal justice system, but I ended up going out to Florence and running into Kathy Norgard, and when I went out there, I was kind of like, oh man, they had the executions in the middle of the night. It was creepy. I was like, are there angry villagers with torches and pitchforks waiting in Florence for us? And I got out there, and people were playing guitars and singing. We got Steph Kaiser coming to sing for us later, so we're quite fortunate to be able to have him. Thank you, Steph, for coming. And anyway, so I got involved in this whole thing, and didn't really have any particular expertise, and I still don't, except that I think I've just evolved into, as a kid growing up and seeing the movies about Carol Chessman and Susan Hayward playing I Don't Want to Die, and seeing those films and feeling that fear of like, wow, the state could kill me or kill people, and having that fear as a child, it just kind of came back to me. And I think I was at somewhere on a business trip, and I picked up a USA Today, and it said that Pima County, Arizona. had the highest level rate of seeking the death penalty of an urban jurisdiction in the whole country. And I said, that just doesn't compute. I understand we're Arizona. We want to be tough on crime. We don't like to tolerate. And we're all horrified by a lot of these things that happen in our community. But, you know, that just didn't fit to me. So I somehow got involved in my activism with it. And I've stuck with it on and off. I dropped out here and there and come back. So I just want to give a little, and I think we all evolve. And I think and we're all connected. My kids grew up with Barbara Wall's niece and nephew, actually, out on the northwest side. I knew her sister, Susan, very well. We were friends, raising children. So we all feel like we're part of the community. We might disagree on things, but we're still civil, and we like each other in general. I actually taught Steve Neely how to fly fish. He said, I'm going where there's no crime. I'm going to New Zealand. I need to learn how to fish. I'm like, and I heard he's back in town. I haven't seen him, but I liked him a lot. You know, I see him out on the soccer fields with the kids, and you know, and I got to know him as a person and his wife. And there wasn't any, even though I opposed the policies at the time of the office, I didn't have any animosity towards him at all. Quite the opposite. I liked him and respected him. Anyway, so I think, you know, I think it's really important as we evolve in our you know, feelings towards the death penalty and criminal justice system, that we understand other people who have evolved. And my position is involved a lot seeing the kind of pain and suffering that gets spread by the death penalty, you know, rather than healing and helping us. You know, it's because we've had a fellow, Joe Hedgecock, who was a juror who had terrible problems. He was on the Ray Crone trial, felt terrible about it, he still does. He had serious problems. So the attorneys, my kids played with a guy named soccer with Jim Heimlich's kids. I'm sure you knew Jim back from the day. He's since passed away, tragically quite young. But so, you know, they're all people, and it was kind of surprising to hear they're involved in the death penalty and all that kind of stuff. But it was still a small community. We're all friends. We looked out for each other's kids, and we still do. And so it's like when I see somebody and I see prison wardens and guards and jurors and witnesses and judges and attorneys who've been involved in this process, I just have my appreciation of all the problems that have come out of it, you know, have evolved. And that's why it's important, I think, to hear from people whose positions have evolved. And, you know, especially people who are so intimately involved. They're not just all defense attorneys and not the defendants. It's a large group of people every time. And most of us have no contact or very little contact with a death penalty case, you know, but since then we've met Ray Crone, we've met exonerees, Paris Carragher. I've never met him, but we brought people in to speak, and that's always a powerful thing. So somebody's been exonerated. So now it's like, you know, it's my honor to introduce Rick Unklesbay today, that he's been with the prosecutor's office for a long time. So I took a few notes here, and he came out of the U of A. He was a Juris Doctor in 1980. He was a bachelor's here. He's been involved in the community. He was a deputy county attorney from 1981 to 2010, chief criminal deputy, chief trial. And part-time. Now he's a part-time deputy, is that true? Yeah, and then he's at the law school teaching part-time. And now he's the conviction integrity unit. He started that and he heads it up. So that's looking at a lot of old cases to see where there are problems. And yeah, I mean, some of them, you know, we found ourselves sometimes in the spotlight, the national spotlight here in Tucson of all places. You know, that Gary Triano thing, he was involved in that. You were the prosecutor on that. I happened to drive by right after that happened up at La Paloma. So it's, again, the theme of Tucson's a small town, and, you know, you're somehow connected. I mean, that was a bombing case, a very, you know, spectacular case that got all kinds of national attentions. The Shauna Ford case down in the immigrants. Really a case of really true evil, you know, of people, white supremacists who decided to rob and kill a family because they wanted to, as I understand it from a distance, that they understand they want to finance their anti-immigrant border stuff. So we've had some, and of course the Gifford shooting and all that stuff that, you know, that really put us on the spotlight. Now it's a site of mass shootings, and our county attorney thankfully did not pursue anything aside from the death, aside from the federal case. So I think we found ourselves in a spotlight, like it or not, and I guess any community of any size it happens to. But, but I appreciate the people who've been involved in the system, who've, have evolved in their position. And Rick's book, Prosecutors, sorry, the name of it again, it's online. And pardon? Arbitrary Death, yeah, Prosecutor's Perspective, that he's come out with, is really quite an important book. And we're very fortunate to have him here today. And I won't go on any longer. Without further ado, thank you, Rick Unklesbay.
Hi there, everybody. I feel like we should be sitting closer and around a table here. I feel really removed from you all, but I guess if they're going to do these cameras, it's best that I stay up here, I suppose. But so I really do better with questions and answers. So anytime anybody, Rod said we're going to have a Q&A afterwards, and if you have questions while I'm talking to you a little bit, you just let me know, and for the benefit of the cameras, I'll repeat your question. And I can't really see people in the back. It's kind of dark back there. I see Laura. So yeah, I've known Laura for a long time. She's a wonderful person. Obviously, you guys know that already. I didn't realize I knew her for as long as what she just said, and it makes me feel kind of old that when she was 14, I was giving some sort of lecture at the law school or something. So that was a while ago. I was trying to remember exactly when this was, but about 20 years ago, I think I gave a talk to the local chapter of the ACLU, and one of the things we talked about was there was a question about how long I thought the death penalty would last, not just in Arizona, but across the country. And at the time, my opinion was, and I told this group that I thought that the death penalty would be abolished within about a dozen years. And this was 20 plus years ago. And the country made some strides towards that through the Supreme Court's decision about juveniles no longer being subjected to the death penalty, those that were what we used to call mentally retarded no longer being subjected to that, the decision that the court made about juries and not judges having to make the most important decisions. And much of the death penalty, there was a whittling away of that, to the point where many of us thought that the Supreme Court, in the early 2000s at least, was on track towards declaring it unconstitutional. Obviously, I was wrong in terms of the dozen years, and I'm certainly wrong now that at least with the current makeup of the U.S. Supreme Court, I mean, that's not going to happen. With the folks that have come on in the last 3 years, especially, I see no prospect that the U.S. Supreme Court is going to declare the death penalty unconstitutional. But that doesn't mean that it's not going away. I mean, you guys, obviously I'm preaching to the choir here, but you guys have more knowledge about the death penalty than most of your average citizens, which is why I wrote the book, and I'll get into that in a couple minutes here. But what we've seen is this dwindling use of the death penalty, and a growing number of states who have decided that they simply don't want to be part of it anymore. When I started giving talks about the death penalty some years ago, there were 38 states that had the death penalty. That number now is at 29, and Colorado actually just introduced some legislation to abolish the death penalty in that state, and it's gotten a lot of support. They tried it last year. It didn't get much support bipartisan-wise, but this year I'm told that it has bipartisan support in Colorado. So it looks as though Colorado may be another state that does away with the death penalty soon. So it is, I mean, I don't mean this to be a joke, but it is dying a slow death. The death penalty is. What we see are more and more states that are abolishing it. Washington did, as I'm sure you're aware, where their Supreme Court declared it unconstitutional because of the manner in which it was employed there. And so it is not only just a fewer number of states that are using the death penalty, that have it, but as I'm sure you're aware, there are fewer and fewer counties within the states that do have the death penalty still that are utilizing it. And so it's really a handful of counties in a growing smaller number of states that are using the death penalty. So one of the issues that caused me to write this book, and has anybody read the book at all that's here? A couple of you read it. So first of all, it's on Amazon, and I'm not trying to hawk it here, but I don't make any money on this. All the proceeds go to a nonprofit. So I don't feel bad when I tell people to buy the book on Amazon. It's Kindle and paperback. Other than what I was surprised, I'd never written a book before, and I was surprised at how much the publishers actually take of the money. But the remaining profit goes to a nonprofit here in town called Homicide Survivors. You may have heard about them. They deal with surviving family members of homicide victims. They give them sometimes they need funeral expenses taken care of. They need help getting to the trial. So Homicide Survivors gives financial aid. They'll sit through court with the victims when the trial's going on. So they're a good organization. So they get all the profits. So I don't get embarrassed about trying to tell people to buy the book because the profits go there. But one of the reasons I wrote the book, I've been involved in capital litigation for a long time, and every year, and in fact last year, there's always national polls about public support for the death penalty, and it's still in the majority of folks who support the death penalty. But it occurred to me over the course of years that one of the reasons for that, I think, is that people don't really know what's involved in these cases. They don't know what a death penalty case is about. The polls go out and it says, gee, do you support the death penalty for people convicted of first-degree murder? And it sounds reasonable, right? And so people say, yeah, I guess I do that. But what I thought in writing this book, what I thought about is that people don't really know what's involved in these cases. They don't know who gets the death penalty. Probably just as importantly, they don't know who doesn't get the death penalty. They don't know the cost of putting on these cases and the decades of appeals that follow. They certainly don't know the reversal rate that comes about with these cases, and how, from my perspective, how it impacts victims, not just as we're trying these cases, but 10 years, 15 years, 20 years or more down the road when these cases come back from whatever appellate court has reversed it and the victims are thrust back into court once again. So when I look at these polls, and it is a dwindling percentage of people who express their support for the death penalty nationwide, but like I said, I looked at some polls the other day, and I think I saw one that was in the mid-50s. I think there are some that are around 60% or so. And I wanted to say, those people don't know why they support the death penalty. All they know is somebody died, and they think that there needs to be some sort of equal reaction to that. So that's why I wrote this book. It's called Arbitrary Death. And that was always going to be the title, because I think to me it expresses what cases get the death penalty and why. And it really is an arbitrary process. So I thought I'd talk a little bit about that. And I don't know how long you guys are meeting. Rod told me, and somebody needs to cut me off at some point, because I can talk for a long time about this, but I don't want to take up your whole afternoon. But what happens in these cases, and again, I know it's interesting to talk to you guys, this group here, because I know you know so much more about the death penalty than the average person that's walking around the street. But so forgive me if I tell you things that you're already well familiar with. But the arbitrariness of the death penalty there's examples of it throughout the process. And in the book, I mentioned a number of different ways that it's arbitrary. It starts with the prosecutor's decision itself. I've been a prosecutor since 1981. I still work in the county attorney's office. I'm still a prosecutor. So I think I'm uniquely qualified to say that it's an arbitrary process. We try to be as scientific, perhaps, as fair as we can. I mean, we don't go in there with the idea of, oh, we want to go in and get the death penalty on as many people as we can. We really do try to limit the death penalty notices to people that are the worst of the worst, that the Supreme Court has always told us about. But what I describe in the book is that this process, we're all human, first of all, and these murders affect us just like they affect other people, and we see them, and sometimes it's the most horrible thing that you can imagine. You've all seen, crimes here in Pima County, and as prosecutors, when we go out to the scene, when we deal with the victims' families, it's horrific, and it's hard to set aside those personal feelings. As much as you try to set aside your personal feelings, when you've been out to a scene and you've seen several people slaughtered for no reason at all, and that sticks with you. And so the idea that prosecutors can be dispassionate and clinical in deciding who gets death, it's a very difficult thing to do. Try as we may, we're all human, and so the decisions that we make at the beginning of who gets death, I describe them in the book as arbitrary in themselves. There are many criticisms of the death penalty, and my book doesn't get into all of them because it would have been 1,000 pages long. But what I tried to do were take cases that I prosecuted over the course of the last, I think one of them goes back to the early 1980s, where I wasn't even the original prosecutor. Jim Heimlich, that Rod was talking about, was the original prosecutor, and I got involved 30 years later, because the people that got the death penalty in the early 1980s, 30 years later, that case was back. So I used cases that I prosecuted in one fashion or another to talk about how the system is arbitrary. So we start off with the prosecutor's decision itself. Although we have statutory guidelines, we have aggravating factors, as you know, where the prosecution has to be able to prove at least one aggravating factor before you can seek death. We have so many aggravating factors in Arizona. We used to have 14. The legislature, as you know, probably just reduced that down to 11. That's still a lot of aggravating factors, to the point where, if you're an experienced prosecutor, if you have a murder case and you can't find one of those 11 factors to be an aggravating factor in your case, you're really not looking very hard, because they're so broad that you can really fit any murder case in there. So even though we have the statutory guidelines, we sit around, we talk about it. We have a panel of experienced attorneys who look at these cases about whether they should receive the death penalty. But it really comes down to a human decision. I mean, there's no objective way that you can decide whether something is a death case or not. It's a very subjective decision. So that's the first way. Another way is who the judge is that gets assigned to the case. That was really true before Arizona versus Ring, that said juries have to make these decisions. But back when we had judge sentencing, it was totally dependent on who the judge was about whether your case was going to ultimately end up with a death sentence or not. But even now with juries, it still is very much dependent on who the judge is. Some of you, if you know any of the judges, some are ardent supporters of the death penalty. I know some that are would love to see it go away. And decisions that they make, and I don't want to say judges make rulings based on whether someone might get the death penalty or not, but again, judges are human, and when they make rulings on pending motions about the admissibility of evidence, about whether the defendant's statement can be used, about whether the police conducted the search warrant appropriately, in the back of your mind, you're always thinking, well, the decision I make could lead to a death sentence, and if I have any doubt at all about this, I'm certainly going to lean in favor of the defendant and not allow the evidence in. Other judges that might support the death penalty may not view it that way. So it again, even though we have this vast body of law that tells us how we're supposed to handle these cases, it still comes down to subjective decisions. So that's the second way things can be arbitrary. Who you get on your jury. I heard Rod talking about somebody that was either part of the group or now or before that was on Ray Crone's jury, and I'll talk about that in a second as well, in just a second. But who's on your jury makes a big difference. I had a case a few years ago that it's in the book. It was the rape and murder of a little 7-year-old girl out in Ajo. And because of the nature of the murder, the age of the victim, we sought the death penalty. The jury convicted the defendant of the murder, of the rape and murder, but ultimately spared his life and voted for a life sentence. And I talked to them for a long time afterwards. And I talk about this in the book, but the jury sat down with me afterwards and said, even though the jury gets instructions in the guilt phase, you're not supposed to consider punishment in terms of deciding guilt or innocence, right? But in the penalty phase of a death penalty case, that's what they're supposed to do. They're supposed to think about that. Well, they went beyond that, and they said, even though we didn't get any evidence about it because the Supreme Court has said we can't allow victims to give an opinion one way or the other about whether they support death or don't support death. The jury said, we're familiar enough with the death penalty system that we didn't want to put the victims through the next 20 plus years of appeals. So they had no sympathy for the defendant at all. Their decision to impose a life sentence was because they didn't want to subject the victims to decades of the potential of coming back to court. So I thought that was just fascinating to me. I thought that here was the jury thinking outside of what really the scope of their duty was, because they were supposed to decide the existence of aggravating factors, and then they were supposed to decide what sort of mitigation there is that applied to this defendant. They do this weighing process, and if they don't think there's a sufficient mitigation to impose life, then they impose death. In fact, our statute says they shall impose death unless they find mitigation sufficiently substantial to call for leniency. But this jury, I was really impressed with their intellect, with their ability to see the overall picture. And they said, we weren't really all that impressed with the mitigation that was offered. He had a bad childhood. He had some potential mental health issues. But they said, but what we ultimately decided the case on was we don't want to do this to the victim. And that's not something, that's not in the statute. There's nothing in the statute. There's nothing in our case law that says the concerns of the victims should control. And in fact, as I said just a moment ago, the U.S. Supreme Court has said victims can't give their opinion about whether life or death is the appropriate sentence. So we take them out of the formula altogether. But this jury was smart enough, and that's what they decided the case on. So, another jury would, I've had a lot of juries who don't look at that at all. And so in the book, I talk about that being yet another arbitrary way in which the death penalty is decided. I spend a lot of time in the book talking about the appellate courts as well, and what appellate courts, including the U.S. Supreme Court, have said about the death penalty. And to me, that's the biggest arbitrary factor in the whole thing, because if you're in the Ninth Circuit, such as we are, it traditionally, although it's changing some with the rapidity with what this administration now has been appointing and getting new judges on the bench, on the federal bench, and the Ninth Circuit is becoming less liberal than historically it's been. But if you're in the Ninth Circuit, traditionally, if you had a death penalty case, there were the chances of it actually carrying through to a death sentence were minuscule compared to other circuits. I always forget what circuit they're in, but if you look at Texas, Virginia, Florida, the circuit courts there were much more likely to affirm the convictions and sentences of folks that were brought whose cases were brought before them than the Ninth Circuit. So, I mean, we don't have, the law is not applied the same across the country. It's very much dependent on what circuit you're in. So that itself is arbitrary. And even when in the Ninth Circuit, I'm sure you're familiar with there are different panels of judges within the Ninth Circuit itself. It's not just dependent on the Ninth Circuit, it's also dependent on which panel your case might fall in front of for ultimately the decision of life or death to be carried out. So all of these things, you know, we in law we like to think that we are objective, that things are black and white and not gray, and that decisions are made based on the law and the facts. But every person involved in the system is human and subject to the frailties that we all have as humans in making decisions. And so from the beginning of the process through the end of the appeals, I argue in the book that it is an arbitrary process. I have a bunch of notes here that I was going to talk about, but I don't know if there's any questions as we go along so far. No, oh, yeah, great, thank you.
So you mentioned the statute, the language shall, and what effect, if any, do you think that shall language has on juries in deciding who has the responsibility for the death? Is it the individual juror, or is it the law that requires the death sentence? And the second part of the question, I'm sorry for that.
No.
Would you endorse the measure, there's going to be a bill introduced in the legislature this session, a one-word edit to that statute, changing the word shall to may to reflect the law, which is that the death penalty is only authorized in those circumstances, not required. It's never required because mitigation can be anything.
All right. So for purposes of the camera, let me see if I can summarize the question. So one, earlier I was talking about the fact that when juries get a case and they get the instructions, that the instructions the court gives track the currently existing Arizona statute, that if the jury finds that mitigation is insufficient to call for leniency, that they shall impose death, is the current law. So that was part of the question. And then I think the other part was I don't want to paraphrase it wrong, but
What impact is that language shall, you think, have on the jury's determination as whose responsibility is their individual decision or the law's requirement?
Okay.
Would you support amending that word to may?
All right, so the other part of the question is the impact that I think at least this term shall has on juries in terms of them following the law and imposing death, and would I support a change in that? I didn't know about the bill, first of all, that's pending. It's troubling because you're also, in your question, you also said that the death penalty is not something that juries have to impose, that it's an option that they have. And I do think that word shall can have an impact on juries. Not always, because as I just told you, the case that I mentioned in Ajo, the jury was given that instruction that if they found mitigation insufficient to call for leniency, that they shall impose death. They totally disregarded that in this case, because they told me that the mitigation wasn't sufficient for anything, especially in light of the facts of the case. It was a brutal rape and murder of this little 7-year-old girl. So the jury disregarded that, despite the fact that it's in the statute. So I'm not sure what that tells us overall, because I've had a lot of different cases where other jurors, and I guess this goes to the arbitrary nature of it, other juries might look at that and say, it says we have to, and if that word is shall, we didn't really like the mitigation, we didn't think it was sufficient, and the law says that we have to. And you're right that in the course of your question, you said the jury doesn't have to do that at all. And we do have some language in the instructions that tells them it's not a requirement, but then we go ahead and tell them it shall. So they're really conflicting messages. That's part of the problem that we have with instructions overall, is we give lots of mixed messages to juries about what their duties are. I mean, just as one example, I think I mentioned earlier, in one part of the trial, we tell them, you're not supposed to consider sentencing. And then in the next phase of the trial, we're saying, we want you to decide sentencing. So the people that you get down for jury trials and the people that make it onto the jury there's nothing wrong with them, but they are people that pretty much have never given much thought one way or the other to the death penalty. So I'm rambling a little bit. I don't know if I answer your question, but one, I think that, I think that the word shall can have a dramatic effect on a jury, and it's not really consistent with our death penalty jurisprudence overall about what the jury's duty is in that. So I think it does have an impact. So I think if I don't think our legislature has a whole lot of interest in changing anything about the death penalty, and they should. And here's why they should. For the most part, we've got 3 Democrats running for county attorney in the next election. All of them have stated that they would do away with the death penalty, and it's more of a Democratic posture or platform than it is Republican or conservative. But conservatives really should be, in my opinion, more concerned about the death penalty than liberal Democrats. And I mean, I'm a liberal Democrat and I work in the death penalty system, but I have qualms about it. I have concerns about it. Mine aren't so much of a moral or philosophical concern as it is to who the death penalty applies to. But I think there's an argument to be made that conservatives, especially fiscal conservatives, should be more concerned about the death penalty than other folks because of the money that we spend on these death penalty cases. 20 years back from 2000 to 2002, I was on Napolitano's Capital Case Commission. And we for 2 years, we looked at death penalty cases around the state and tried to come up with a bunch of conclusions about it. One of the things that we tried to figure out, and this was 20 years ago almost now, one of the things we tried to figure out was how much a death penalty case cost. What's it cost to the taxpayer? We actually hired an accounting firm who spent 6 months trying to look at it and came back to us and said, we don't know, because there are so many variables. There are so many different courts that are paying attorneys, and especially when you get to the appeals that run for 20 years or more, it's hard to figure out what they cost. I mean, you can go online and you can pull up any number of studies that will tell you what a death penalty case cost you. And I mean, I've seen some that are as low as $1 million. I mean, that's a starting point for any death penalty case. I mean, if anybody told you it cost $1 million to do a death penalty case, I mean, that's way low. I mean, do they cost $3-4 million? Probably. But I mean, I've been involved in the system for a long time, and I can't tell you what it costs. I mean, I have some statistics for what it cost me to try a case like this. Rod mentioned the Arivaca case. I tried that back in 2011, and we had 3 defendants. We had back-to-back trials. We had 6 defense attorneys involved in it because each defendant was entitled to have 2 defense attorneys. So just the trial of those cases cost the taxpayers of Pima County, just for the defense cost, to pay the attorneys, to pay the defense experts, cost us $1 million in taxpayer money just to try those cases at the trial court level. It's now 2011 was 9 years ago, I guess. So 8 years ago since the trial's finished or so. We are well above the original $1 million that we spent on the case. Now, it was going to cost us some money, obviously, to try the cases, but nowhere near $1 million that we spent on expert witnesses and extra defense attorneys. I checked recently, and the cases are still at the state court level. So, as you know, once the state court level appeals are done, it goes into federal court, where that's when the real time and money starts, right? I mean, they languish there for years. But just in the state court level, we've spent at least another $1.5 million just doing the direct appeals. This is just the defense cost. So we're, we're 9 years in, we are somewhere between $2.5–3 million that we've spent on this one case. And one of them didn't get the death penalty. Two of the three defendants got the death penalty. So two of them will have appeals for the next 20 years. And so that $3 million to the Arizona taxpayer is going to grow exponentially over the course of the next 10, 15, 20 years. I started out saying that that's why I think that fiscal conservatives should be more concerned than even a group like yours, because I mean, the idea of the amount of money that we're spending on these cases, especially if you want to look at it from a basic economic standpoint, if you look at the return that you've gotten on your money. So I like to use California as an example, just because they're the elephant in the room. There are last I checked, there are 741 people on death row in California. In the past 30 years, California has had 13 executions. They got 741 people on death row. They've had 13 executions in 30 years. Each one of those 741 people are still appealing their cases. The amount of money that is being spent on that is staggering. In Arizona, we have roughly, obviously it varies day to day almost, but we have about 120 people on death row in Arizona. We've had, I think, 37, 36, 38, somewhere between 36 and 38 executions in the last 30 years. And that's not just of that 120, it's of all the people that have been on death row since Arizona reinstituted the death penalty. So the return on your money, just from a clinical sense, set aside whether you have a moral or religious or philosophical objection to the death penalty, if you just look at it in terms of the expense, the fiscal responsibility, that alone should cause conservatives to be concerned about the money that we're spending and we're not getting, if I can crudely say, the bang for the buck kind of thing. So there are a number of reasons why the state should do away with the death penalty. And so there are moral reasons that folks have, but there are, to me, more pragmatic or practical reasons that it's arbitrary, which is why I wrote the book. It costs a lot of money. And you look at who doesn't get the death penalty. Rod brought up, a few years ago, I prosecuted the Pam Phillips, who was found guilty of having her husband, Gary Triano, blown up at La Paloma. We couldn't seek the death penalty on her. But she had a pipe bomb. She didn't do it herself. She had hired somebody to place a pipe bomb in the front seat of Gary Triano's car. And when he got in the car, they remotely detonated it. And he died a horrible death, being blown up in his car. We couldn't seek the death penalty against her because she had, I say fled, her defense attorneys say moved, but she'd relocated to Europe. And to extradite her out of the European Union, we had to agree in writing through the State Department we would not seek the death penalty. Otherwise, we weren't going to get her back. So that's another, I devote a chapter to our international relations in that sense of why that's arbitrary in itself. We extradited a guy out of Canada that had killed his wife in Tucson. Canada wouldn't give him to us unless we agreed not to seek the death penalty. Pam Phillips, there are other examples of that where, it's no less arbitrary that some other country or European Union has decided you don't get this person, you can't prosecute this person unless you agree with our stance on the death penalty. So it's all those ways, the people that don't get the death penalty. One of the cases I talk about in the book that to me illustrates the plane going overhead here. Let me just pause for a second. One of the cases I talk about in the book is a guy that I tried twice to a jury, and it's a guy named James Granville Wallace. He's been on death row since the mid-1980s. I wasn't the original attorney on that either. In fact, he never had a trial. The crime occurred in 1984. Thank you very much. The crime occurred in 1984. James Granville Wallace killed 3 people, his girlfriend and her 2 children. It was a horrific set of murders. He had confessed to everything. He told the cops what he did. He told his friends what he did. He was horrified about what he had done, but he killed bludgeoned these people to death. He pled guilty to it and was sentenced to death in the 1980s. Well, in 2005, so almost 30 years later, I found myself taking him in front of a jury, post-ring, having the jury to decide these issues about whether he should get the death penalty. The first jury in 2005 heard the facts of the case and decided that he deserved the death penalty for what he did. Arizona Supreme Court reversed it in 2008. They didn't like the instructions that we had used to define the law that existed back in 1984. We tried it again in 2010, separate jury. They didn't know what had happened at sentencing in the 1980s. They didn't know what had happened at sentencing in 2005. And in 2010, a new jury imposed death upon James Granville Wallace. This was now the 4th time that he had received a death sentence. And in 2012, the Arizona Supreme Court said, you know, in our independent review, because they still got to do that because it was a pre-2002 case, said we just don't think this is a death penalty case based on the law that existed at the time. And I always tell people, I mean, if James Granville Wallace, if you're not familiar with this case, again, get the book or read the opinion in his case. It is the most horrific set of murders that you can imagine. If he doesn't belong on death row, then who does, is what I often tell folks. So the arbitrariness of people who commit horrendous, horrific, awful murders are not subjected to death. But we have many people on death row who committed one murder, and not to diminish the crime that they committed or diminish the value of the victim in those particular crimes. But, you know, if people who committed an armed robbery, shot somebody and the person died during the course of that, and they're on death row, well, we have people who committed horrible offenses who are not. And again, illustrating what I argue in the book is again, the arbitrariness of the system as it exists. I go a step further than just talking about being arbitrary, but I argue that there's no way to fix it either. There's no way to constitutionally fix it so that it's not arbitrary, but yet still constitutional. All right, so let me just see. Yeah, I mean, I had some other things written down here, but I mean, really, if anybody had any questions, I'd be happy to answer that. True. Yeah, Rod. Oh.
Oh, thanks. Yeah, I promised Punch Woods to ask a question because he's read your book, and I think you just answered it pretty clearly. But do you feel like it's fixable? I mean,
Yeah.
given the arbitrary nature, and do you feel,
Yeah.
that given human beings being what we are, flawed? And,
Yeah. Yeah, so there's the question was whether it's fixable. I mean, I think there's a couple reasons for that. One, as I've already addressed, that the system is run by humans, and we make mistakes. I mean, you brought up Ray Crone earlier. You know, we know with certainty that Ray Crone was not guilty of the murder for which he was twice convicted, right? If you've been in Tucson for a while, I know some of you have been here for a long time. If you remember Larry Youngblood, it wasn't a murder case. Larry Youngblood was convicted of a child molestation by my office in the mid-1980s. We discovered in 2000, through the use of DNA, he was not the molester. And so we know with certainty that Larry Youngblood did not commit the molest that he was convicted of in 1985, 86, whenever that was. He spent a number of years in prison for that until we were able to say with certainty it wasn't. So it's a human-run system, and a system where we know that we make mistakes, and so can we live with a system in which it is possible at some point in time, if we haven't already, convicted and executed somebody who didn't commit the crime? So it's human run. The other reason I say it's not fixable, I mean, because of our jurisprudence, I mean, juries have to consider mitigation and weigh that mitigation. And I mean, you could make you could make the death penalty system less arbitrary by saying, if you killed 10 people, you go back to this word shall, you shall get the death penalty. But we're still got to take into account mitigation, and it's going to have the same vagaries and arbitrariness that the system now has. And our Supreme Court has told us that we can't have the death penalty with that specificity either. So for a number of reasons, I discussed this a little bit in the book. I don't go off too much on it, but I don't think it's fixable and maintain the constitutionality of whatever statute, however we might try to fix it. So I don't think it's fixable. So we're gonna sort of string along, I think, for a while longer. I don't know if the states that are doing away with the death penalty, if they're going to, sort of this ball rolling downhill where it would kick up with some speed. But I mean, recently we had, as I said before, the state Supreme Court declared that statute, their law unconstitutional. Colorado looks like they're going to do away with it. The legislature in Nebraska did away with it before the voters decided that they didn't like what their legislators had done. But we see across the country, folks just don't want to deal with it anymore. And for the legislators, I know a couple up in Phoenix, and I've asked them to read the book. I don't know if they had, but I think the idea of the fiscal irresponsibility of what our system brings about should be something that our legislature should look at. So, yes, sir.
Same topic, I think. Most of the people here have met somebody who lived on death row who didn't commit the crime. I've met 3 that are not on death row anymore, even though they were convicted of it and served years there. But they're not on probation, they're not wearing an ankle monitor, they're free because they never committed the crime. So, what do? I mean, we can't give them back the years that we took from them.
No.
And yet we tried to kill them, even though they never committed a crime.
Yeah. So the microphone, I assume, is picking up on the feed here, so I don't have to repeat those. But some states, Arizona does not. Some states have a fund that tries to make at least the attempt to make whole. You can never make whole. You can never give back those years, as you said. But many states have a fund that at least pays a certain amount of money to the inmate who was wrongfully convicted. I don't see any political will in Arizona for such a fund coming about. Ray Crone, sued the state because of his, and I know there was a settlement there, but Crone had to take extraordinary methods to get some sort of compensation for the years that were taken from him. But all that does is illustrate, I think, that if we have a system that can make mistakes, that we know makes mistakes, then that's the whole issue. Should we have a system in place where we know that those kind of issues arise, where we can convict the wrong person and they're in prison? And God forbid, as a prosecutor, the last thing I want to do is put an innocent person in prison, and certainly subject them to the death penalty. We try very hard not to do that, of course, but again, the system is run by humans, and all those human frailties are out there. So, if I were in their position, I don't think anything that the state or anybody could do would bring me back my life, give me back what I had lost. We simply can't do that.
Thank you. My question is more along the lines of prosecutorial duty, and the first thing you mentioned was that the arbitrariness in the decision-making process in the beginning of the case is really unfettered discretion. Would you advocate in any way that kind of more judicial oversight, Or are you more in favor of having the prosecutors still make that decision to
You
go
know,
for a death case?
Yeah, and, it's a good question, and I can give you a couple different answers to it, and they're sort of different. I'm sort of flip-flop on that a little bit. But both the American Bar Association, well, there's a number of groups that have come out with a recommendation for centralized decision-making. I have a friend who's an appellate court judge up in Phoenix, Kent Katani, who worked at the Attorney General's office for a long time, was the supervisor of the death penalty appeal section there. He has advocated for a long time that Arizona have a centralized decision-making body. His suggestion would be it would be the Attorney General's office that would make a decision as to whether or not a county could impose or file for a death notice. I think there's merit to that. And the merit that Kent proposes is that if the counties go through the centralized system, then the state would pay the expenses for the county. So the defense expenses, the prosecution expenses, that's sort of the lure of counties wanting to do that. Because the county attorneys are independent officers, they're elected in each county, it's their jurisdiction to make these decisions. And so, I mean, I've talked to just a handful of people in different offices, and I haven't heard of any county attorneys who are willing to give up that authority. And it's not because, I don't think it's because county attorneys want that power necessarily, but the answer I get is that, I'm responsible to the constituents in my county, and they hired me, they voted me in, they hired me to make those decisions. So I haven't seen anybody that's willing to give up that authority. But that brings up another issue, and in terms of how the death penalty is applied, and you look at the difference between Pima County and Maricopa County. Maricopa County, right now we have 3 pending capital cases in my office, and Rod mentioned something about Pima County being one of the most active. And in the 1990s, we certainly were. We've become much less so in recent years. Maricopa County has 40-some death penalty cases that are pending. And what are they, like 6 times the size of us, county-wise or something? But they have 16, almost practically 20 times the number of death penalty cases that we have. And you look at Pinell County had, last I checked they have in the teens, they have something like 14 or 15 death penalty cases that are pending in Pinell County, which is much smaller than us. So it's another illustration of sort of this arbitrary argument that it depends on the geography. We think globally sort of, it depends on the geography of where what state you committed your murder in and whether that state has a death penalty or not. It's much more local than that. It depends on where you are in Arizona when you commit your murder. If you're in Pinell or Maricopa County, chances of your case being a death penalty case are much greater than if, Graham or Greenlee or, Gila or whatever it might be. Even in Pima County, your chances in those other 2 counties, it's much greater your case is going to be a death penalty case than it is here. It didn't always used to be that way, as I said, but it is now. And again, it sort of illustrates this arbitrary nature of its geography as well. There's lots of things to talk about in there. Other questions? Yes.
Just a quick clarification, because earlier you mentioned, even though we are mostly liberals in the organization, we're nonpartisan, and we would welcome conservative Republicans or conservatives of any ilk to join our cause. So I just wanted to clarify that for the folks who may be listening on the live stream. But
I certainly didn't mean that in a pejorative sense at all. So.
The title of your book, Arbitrary Death, it seems to have some connection to Furman v. Georgia and the holding there about the split holding there of the death penalty in the 70s being arbitrary and capricious. And you mentioned the statutory guidance that the legislature created in response to Furman to provide that guidance to prosecutors and jurors eventually as to when to seek the death penalty, with a number of aggravating factors swelling up to 14 down to 11. Recently, in a case called Hidalgo v. Arizona, the litigants there challenged that scheme as failing to narrow. And you mentioned that any prosecutor could find at least one aggravating factor in any death sentence. The United States Supreme Court, 4 justices indicated that they were willing to look at the case, but because the Maricopa County Superior Court declined to conduct an evidentiary hearing where that data was put to the test, they ultimately declined certiorari in that case, and Justice Breyer indicated so in his statement. Do you think that, given those facts and that history, that if a litigant were to continue with those claims, that they should have some sort of due process right to an evidentiary hearing to develop those claims? What do you think about the Hidalgo-Furman claim and the ability to test those in an evidentiary hearing?
I really thought that the courts up there would allow for that type of a hearing, here's ultimately the problem. Had that claim been allowed and come up in the Supreme Court that existed, 10 years ago, or 10 to 15 years ago, I think there would have been much more receptive audience to it at that point. But I don't see it going anywhere at this point in time. But the argument certainly is there, and it sounds like you're quite familiar with those arguments, but you look at the aggravating factors that we have, and they just got rid of some of the ones that were the most incomprehensible. But we still have the most incomprehensible aggravating factor, and that's the especially cruel, heinous, and depraved. I talked earlier about that prosecutors and ultimately juries, as you say, have these statutory guidelines on how to decide the cases. The aggravating factor of especially cruel, heinous, and depraved, there's however many of us that are sitting around here today, we could come up with that many opinions about what those terms mean. And even Scalia wrote that our death penalty jurisprudence is incomprehensible, was the word that he used. So, yeah, the Hidalgo, sorry, I'm getting an echo of the plane up here or something under the covers, but the Hidalgo issues, I really thought that they were going to, I really thought that was going to be a big deal, that they were going to have the hearing up there, where there was going to be this idea of a hearing about what all these aggravating factors meant, how they were applied, and it just sort of fizzled out. So, smarter people than me are thinking about how they can bring that back up. But ultimately, what's this U.S. Supreme Court going to do with it? I don't see them doing anything with it.
If I can have a quick follow-up, you mentioned Justice Scalia, and I was just wondering, if you take a look at the people here today, do we look like a bunch of people engaged in guerrilla warfare?
No, the overall, the problem that I think that groups like yours have is that there are not enough people who know what you know. And because people don't think about this issue. I mean, obviously, for you to become members of this organization, you're passionate about how you feel about this issue. I don't think most people think about it much. And I say that because, I've picked a lot of juries in these kinds of cases, and the vast majority of people that come down, they fill out 10, 12, 15-page questionnaires about their feelings about the death penalty beforehand. They're grilled about it when they come down for jury selection in voir dire. And there are so many more people who say something to the effect of, I've never really given it much thought. I guess I'm supportive of it. They don't think about it. People don't think about it. So I think that I don't want to label you as an abolition group. I don't know if that's fair or not, but your concerns about the death penalty aren't shared by the vast majority of people, only because they're lacking the knowledge about what our system is about. And so one of the things that, like I said at the beginning, one of the things I try to do with this book is give some insight from my perspective about why we shouldn't continue on with this statute. But it's an uphill climb, because most people aren't going to read my book, right? Most people aren't going to listen to an abolition movement because it doesn't really concern their lives. They don't have any closeness. It doesn't impact them in any way. And so the message has to be, I think, in terms of, you can save money. You can save taxpayer money. And that grabs people's attention, I think, because it's indisputable that we spend enormous sums of money doing these cases when we could be redirecting that elsewhere. And so that was a long-winded answer to whatever your question was now that I've forgotten. I'm sorry.
Hi, speaking of that, when you're evaluating what it costs or trying to evaluate what it costs to have somebody on death row, don't you have to compare that with appeals that go on if they're in for life? Don't you have the same appeal process going on?
I'm sorry, there's planes are going ahead, so if you could.
So don't you have to compare the cost of having somebody on death row to the cost of having them in prison for life?
Oh, okay.
Don't they still
yeah.
appeal that
Well,
as well?
Yeah, well, except that there's two big differences there. So I assume you're talking about people who are given natural life or things of that nature and the cost. So one, certainly it's very expensive for us to imprison people for natural life. As you've undoubtedly seen in your review of these kinds of cases, most of our murders are like young men between the age of 20 and 30, right, or even younger than that, who are going to be spending the next 50 or 60 years in prison, and that's really expensive. I don't think it measures up to the amount of money that we're spending on death penalty cases, but when you factor in medical care, most people don't think about the fact that when these prisoners get to be 60, 70, 80 years of age, that their medical care, despite whatever flaws we have in the prison medical system, that it's really expensive. I mean, I read an article where California actually has an Alzheimer's care facility at one of the prisons because they've got so many aging prisoners that they have, that kind of care is necessary. We have cancer care, we have all sorts of issues that come about due to advanced years. And so we spend a lot of money. So, I usually tell people, in that respective, it's kind of a wash. But, the alternative there is that my personal opinion, and this is not shared widely by prosecutors, but when somebody gets to be 70 and 80 years of age, we need to look for some alternatives because they're unlikely to be a continuing danger to the community. And we're warehousing them in a very expensive facility when there should be some alternatives. And maybe it's some lesser form of custody, maybe it's some halfway house, but something where we're not spending, $30,000, $40,000 a year to keep somebody in prison. So, this isn't just a one issue kind of thing. I think we need to look at prison reform overall, about what we do with people who have committed nonviolent crimes. That's a whole other issue. But the advanced aged prisoner, we spend an enormous amount of money on folks that are older. So yeah, it's a big issue. But we can deal with that in other ways. But the one thing about the appeals, if you get a life sentence, pretty much you get one appeal and you're done. There are post-conviction matters that you can raise, but for the most part, if you've gotten something less than a death sentence, you're going to get your one shot, typically at the lower appellate court, the Court of Appeals. The Supreme Court, it's discretionary whether they want to take your case or not. So you really, for all intents and purposes, you really have one appeal if you've gotten less than a death sentence. And then you're done, and then you're going to serve your sentence. So we don't spend as much money on lawyers and court hearings and things of that nature. Yes, sir.
I just wanted to comment when you're talking about, when you're speaking about health care and the high cost of it, I remember when Robert Mormon was executed in 2012, I think he was given a quadruple bypass about 6 weeks before we executed him.
Yeah, it was actually a quintuple bypass, which I had never heard of. I had to look it up because I thought you only have like two arteries and you have like two going in and two going out, right? Well, obviously there is such a thing as a quintuple bypass, and I couldn't explain it to you, but the state of Arizona gave Robert Mormon he's an interesting story. His case was an interesting story. If you're familiar with it, don't ever stay at the Blue Mist Motel in Florence, right? In October of 2011, Robert Mormon was given a quintuple bypass so that we could keep him alive long enough, and he was executed in February of 2012, so it was a matter of like 4 months. But we gave him, I tried to find out at one point in time what we spent on a quintuple bypass, and of course there's, all the HIPAA laws, the DOC wouldn't tell me. I was just relegated to internet research. They're expensive. So I don't know how much, the low ball was like $30,000, and I don't know who was doing the surgery on that one that I found, but they $100,000 or so. So in the last 4 months of this guy's life, we spent maybe upwards of $100,000 on surgery to give him this bypass operation, simply so we could keep him alive long enough that a matter of weeks later, we executed him. I use his story sometimes just because I think it's a fascinating, take on our death penalty system, what we do. Anything else? One more question?
Sure, yeah. So, thanks for coming today, Rick, and talking to us. So if the death penalty is arbitrary, then I think, I don't want to put words in your mouth, but I think that the case law says that means it's unconstitutional, right? Furman, that's kind of the conclusion of Furman.
Yeah, I'm using it but go ahead. I'm
Sure,
sorry.
okay, well, regardless.
Yeah, no, I agree.
So with sort of the kind of that insight and sort of the conclusions it seems like you've reached over the years, how does that affect how you are conducting your work? I know you're semi-retired, but in terms of support for seeking death notices or support for continuing capital prosecutions within the county attorney's office, if you think the death penalty is unconstitutional, does that affect your work in a day-to-day sense?
Yeah, no, good question. And so I say, first of all, I'm using it, I use the term arbitrary death in a more generic sense than, because the Supreme Court has looked at it numerous times and in numerous cases and said that at this point in time, our jurisprudence says it's not unconstitutionally arbitrary. There have been a lot of dissenting opinions about that, but our law today is it's not unconstitutionally arbitrary. So my wording of it is more generic than it is meant to be a legal holding. But your second part of that is it's always somewhat of an uncomfortable question, and I've gotten that before because I'm still involved in helping make those decisions in the office. We have 3 people running for office, all of whom have said that they won't employ the death penalty if they're elected. I've known Barbara for the better part of 40 years, and I don't want to put words in her mouth either, but I thought at some point our office might be in a position of not seeking the death penalty anymore. But we haven't. I'm not the elected official. I've had these discussions in the office about whether we should continue on. So I've continued being part of the panel. I've continued being part of the decision-making process. And the reason I've done that, and this isn't a satisfactory answer to some people, and I've told some people, if you just want to say I'm hypocritical about it, you're certainly welcome to do that. But my take on it is that I have a certain amount of expertise in making these decisions. And I think that by lending my voice to the panel, still being involved, I can bring a voice to the table that not many people in my office have the experience to bring that same voice. And I have spoken up at panels and said, this is simply not a death penalty case, where a prosecutor's brought it into the panel, said, here's my aggravating factors, here, I don't think there's much mitigation, and I think we should file the death notice on it. And I have spoken up and said, that's not a death penalty case. And because of my expertise, my voice carries more weight than a lot of people in the office, or most people probably, except for Barbara. So I can bring that to the table. But admittedly, there have been, I won't get into it because it's a pending case, but we have at least one case in the office where my voice was, if we are, and I remember exactly what I said, if we are going to have the death penalty in Pima County, how do you not file on this case? So if we are going to have it, how do you not do it? That's the voice that I think that I bring to it. And so people have told me they think that's unacceptable, that if I have this position, I shouldn't be involved. But it's the job that I have, and I think and my position is I still should be involved because of the voice that I can bring to that table. But you can still think I'm a hypocrite for it. Okay, one more, and then we probably should. I've been up here longer than what Rod told me I was allowed to be up here. So, thank you.
There are a number of former prison wardens who've overseen many executions who, now that they've retired, have come out in opposition to capital punishment, talking about the strain. You spoke of the strain on the victims and the victims' family members in these cases, but they speak of the strain on anybody in the prison system that's involved in it. And one of the individuals that I'm most common with is a woman named Jean Woodford, who was, with the DOC in California at San Quentin, oversaw, 4 executions back in the day when California did execute. And then when she retired, she became the executive director of Death Penalty Focus. And I asked her one day, did you just have a sudden awakening? And her response was, no, she's always been opposed to capital punishment. Yeah. And I was rather shocked. And she said, well, tell me, Dan, would you rather have somebody who was in favor of capital punishment running a prison?
Yeah. So I'm not, by responding this way, I'm not trying to pat myself on the back or anything, but there have been a lot of people who have gotten out of the system, and once they've retired, have come out with their position. I decided I wanted to do this while I was still an active prosecutor, because I thought that my voice would be stronger, because I'm still involved in the system and saying this is a system that doesn't work well. There's a lot of folks that have come out. It is hard on the people who are involved inside the system. It's hard on victims. It's hard on everybody. But the reason I wanted to get the book out while I was still a prosecutor, I thought that it would carry more weight because I do these cases. So like I said, I'm not trying to congratulate myself on that. I just wanted my voice to be heard in that way. So I still do them, and I'm not trying cases much anymore, but I'm still active in the office and do that. But yeah, with a lot of wardens have done that. In fact, there's one prior warden who testifies for the defense in a lot of these cases, and he's been out here. He's from North or South Carolina, I forget which now. Really nice guy, but he testifies for the defense oftentimes about death row and being in prison and what happens to prisoners and how they can be controlled, that sort of thing. Anyway, Rod, I think we're probably done. Anything else? All right. Thanks very much for having me on here. Appreciate it.
Yeah, thank you, Rick. We really appreciate your coming here today. And yeah, a couple of things that should have added were some of the things about the effect on victims' families being dragged out for such a long time. And then also, we just want to let you know, we had our president past was the former chair of the Maricopa County Republican Party, Robert Hungerford. He was a conservative lawmaker, great guy. He's still involved in our board. So it's not a partisan issue on that level for a lot of us. Although we're mostly we almost lost him one time because somebody foolishly said, well, let's identify our political orientation, and he found himself the only Republican. So we almost lost him at that point, but we did. That he's still around. We love him dearly, but he's great. Anyway, so yeah, we got some swag here for sale. Anybody wants to buy that? The other one, we got the books, and what are they? Just take a donation at this point, right? For our the Sun Does Shine book. We've got some of those for sale. That we were charging $20 or something, but now I think we dropped the price if somebody wants to buy one. It's excellent. I've read it. The other part is we have that movie Just Mercy is just being release this weekend, so I encourage everybody, maybe we'll do a group thing down here. The other one, Clemency, it's called, I think it's going to play at the Loft. That's another big time. Maybe we'll have another panel discussion at some point whenever we can get at the Loft or the screening room or somewhere, you know, if we can do a special event, we'll try for that. But yeah, I hope everybody sees Just Mercy. It's a real big time Hollywood movie that's been released, and it's a very wide release right now. We couldn't get a special thing here locally. Anyway, and we got Steph Kaiser coming here to play. Please stick around, people, if you haven't eaten yet. Most of us have eaten. He just moved here from Seattle. We haven't met him yet, but Greg recommended him highly, and I think we'll enjoy him. Thank you, Steph.
Thanks, folks. Give me just a minute.